My name is Taran Champagne, and I would like to thank the committee for giving me the opportunity to speak on the topic of judicial misconduct. My topic of concern today is the current state of the Texas family court system. I will point out the failings of how the family court system conducts itself, and how the family court system flagrantly disregards any semblance of justice. I will start with Title V of the Texas Family Code, Subtitle B, Chapter 153, Subchapter A. Section 153.002, Best Interest of the Child. The best interest of the child shall always be the primary consideration of the court in determining the issuance of conservatorship and possession of and access to the child. Currently, the common rulings provided by the majority of judges in the state do not in any way, shape, or form strive to consider the best interests of the child. The standard possession order, and in some cases the expanded standard possession order, artificially limit time children can spend with one of their parents. In the case of most rulings, though not all, fathers are given far less time with their children. It is generally a rubber stamp process where deviation from these standard orders is lacking. If what is noted on the Attorney General's website is indicative of what actually happens in the court system, 90% of non-custodial parents are fathers. Assuming most of these rulings result in the standard or extended standard possession order, this restriction of time is highly detrimental to the development of children. A few choice statistics can help to elucidate this. Fatherless children are at a dramatically greater risk of drug and alcohol abuse. 71% of high school dropouts are fatherless. Fatherless children have more trouble academically, scoring poorly on tests of reading, mathematics, and thinking skills. Children from father-absent homes are more likely to be truant from school, more likely to be excluded from school, more likely to leave school at age 16, and less likely to attain academic and professional qualifications in adulthood. A study of 1,409 rural southern adolescents, 851 females and 558 males, age 11 to 18 years old, investigated the correlation between father absence and self-reported sexual activity. The results revealed that adolescents in father-absent homes were more likely to report being sexually active compared to adolescents living with their fathers. In addition, the federal government noted the following in their publication, The Importance of Fathers in the Healthy Development of Children. Highly involved biological fathers had children who were 43% more likely than other children to earn mostly A's, and 33% less likely than other children to repeat a grade. And even from birth, children who have an involved father are more likely to be emotionally secure, be confident to explore their surroundings, and as they grow older, have better social connections with their peers. Even with this small amount of evidence presented here, current standard rulings blatantly disregard the best interests of the child. However, these fatherless children are more often than not created not by fathers leaving their children, but by the court system's actions, as evidenced by the following. In the Texas Family Code, 153.001 Public Policy. The public policy of the state is to assure that children will have frequent and continuing contact with parents who have shown the ability to act in the best interests of the child, and encourage parents to share in the rights and duties of raising their child after the parents have separated or dissolved their marriage. Part 1 implies that a parent needs to be proven to act in the best interests of the child. In the syllabus of the court case Troxel versus Granville, it was written that there is a presumption that fit parents act in the best interests of the child. Along with this, frequent and ongoing contact is an ambiguous definition. In the case of the standard possession order, children spend approximately 33% of the nights of the year with a non-custodial parent. In the case of the expanded standard possession order, that is approximately 40%. Even in that case, that is often a difference of approximately 60 overnights per year. Thank you. Part 3 is so regarded that it is ludicrous. The system is founded on conflict. 3 parties walk into the court and enter into a winner-takes-all battle where only one party walks out as the winner, the primary custodial parent. The losers are mainly the child, who has a loving bond with their parent severed and potentially permanently damaged by the court system and the non-custodial parent. This system generates intense conflict that is in no way conducive to encourage parents to share in the rights and duties of raising a child. Both the 5th and 14th Amendment of the United States Constitution state that individuals will not be deprived of life, liberty, or pursuit without due process of law. The overall liberty of children to have equal and ongoing access to both parents is deprived by the courts under the ill-defined and nebulous best interests of the child. Current orders issued by the state court fail to act in accordance with these guidelines and the Texas Family Code, and are often detrimental to our children of the state of Texas. Thank you very much.
Thank you, sir, for your